everyone. We're just going to keep going where we left off last week. I just want to make sure that we take today and tomorrow to finish the notes and make sure that any questions are answered so that we can finish this review this week. So we're just going to get right back into it. Last week we left off with the Fourth Amendment. We're just going to go back through that. We talked about what a warrant was, the idea of probable cause needed to get a warrant. We talked about the exclusionary rule being applied to the states through Map v. Ohio. And we finished off with Terry versus Ohio. So we're going to keep moving today. Hopefully we can get most of this done today so that tomorrow we can just go back and make sure everybody has everything they need to take the summative that will go over all of these slides. I know it's taken some time, but we'll get moving. All right, so we're gonna move through this relatively quickly. The Fifth Amendment is a really big amendment. This is the one where we say, remember, Fourth Amendment, we have to find evidence. Fifth Amendment, we have an accused. Sixth Amendment is a trial, and Eighth Amendment is punishment. So Fifth Amendment is really critical when it comes to what is protected if I'm accused of a crime. And so this is not necessarily inside a courtroom. That's where we got confused a little bit last in Crim 1 was between the Fifth and the Sixth Amendment. So just to review, we talked about due process. Due process is the idea of fair and equal treatment. I don't know if I can do this with no, this is not going to work. Well, you guys get the point. Fair and equal treatment under the law. And we talked about two different types of due process. The substance of the law, the laws must be written fairly and equally. And then the procedural due process is where the laws have to be carried out fairly and equally. And yes, I know we have situations and circumstances where we can look at the laws and maybe challenge if they're equal or the way the law is carried out. But again, our government does try to make sure that these are taken care of, but there are times where that does slip. So again, due process is the idea of fair and equal treatment. Substantive is how the laws are written, and procedural is how the laws are carried out. The next one I want to go through, if I can get this thing to work again, the idea of a grand jury. A couple things about a grand jury that I want to make sure we point out. Grand juries are generally 23 people. We have the explanation here. Let me just pull this up a little bit so I can see who did this one. Oops, back. Roxana, when she did this, she identified this as a group of people who examine evidence. And remember, this is just the prosecution's office. We don't have a judge. There is not, the defense is not present. The defense attorney is not present. We don't have objections. We don't have cross-examination. This is a very sided process to determine, does the prosecution even have enough evidence to charge someone with the crime? And so we have had an opportunity to see that firsthand coming out of New York, where the grand jury has said they believe the Manhattan District Attorney does have enough evidence to charge the former president with some white-collar crimes. That is just the part of the accusation. That is not a verdict. That doesn't determine if somebody is going to get punished. That is simply saying there's enough evidence to go to a trial because the evidence is enough to actually indict. And again, that's a word I want to make sure everybody has and knows is the indictment is the charge. The arraignment is the process of hearing those charges, and we'll get to that here in a little bit. Another one for the Fifth Amendment is self-incrimination. The idea that if I'm the accused, I do not have to give information that can be used against me. And so we talked about I plead the fifth. I'm pleading the Fifth Amendment. Um, what are the other words for self-incrimination? I really like this. Self-accusation, acknowledgement, confession, admission. This is a really major thing that a lot of us never even consider, is that the government cannot in any way force us to give information that would help the government in their accusations and potentially conviction of ourselves for a crime. So really an important thing to remember. And again, it's an easy one. I plead the Fifth Amendment. I'm protecting what I say. Now remember, the witnesses can't use this unless what they testify to is going to be used against them in a criminal trial. So most of the time, self-incrimination only protects the accused. All right. I love that we have the movie Double Jeopardy here because we know that the movie Double Jeopardy isn't actually correct. But Double Jeopardy is prosecuting a person for the same crime. If a trial is conducted and a person is found not guilty, and later they find evidence that actually proves that the accused was indeed guilty of the crime, they can't go back and try that person again. The law protects us. The government gets that one chance. And if they fail to prove guilt in that one chance, that's the only chance they get. And I like that Ryan has included this because O.J. Simpson is, even though O.J. Simpson wrote a book about committing murder, it would have been double jeopardy. O.J. Simpson, after his conviction, could have said, I did it. And the state of California would have never been able to do anything, include get him for lying on the stand, because remember, self-incrimination protects us from even having to take the stand if we're the accused, and OJ did not take the stand. So he never stated anything that would have been able to come up on a different charge of lying under oath because he never took the stand. So again, that's another protection in the Fifth Amendment. It's a really big amendment, and we really often don't ever think about that amendment. All right, moving on to the Sixth Amendment. Once we have the evidence, once we have an indictment, once we have the process of the accused, then we can move on to the trial. And so the Sixth Amendment, for those of you that want to be reminded, this is just the protection of what happens if I am on a criminal trial. I am the accused. I have been charged. What protections do I have now in a trial? So we'll go through and look at what the Sixth Amendment says in the slides here. All right, so again, Sixth Amendment, we got to make sure we understand the difference between the prosecution and the defense. The prosecution is always the side that represents the government that has made the law. So if the prosecution is the state of Minnesota, we are looking at someone who has violated a Minnesota law. If the prosecution is the United States, then it means that we're on a trial because we have been accused of breaking a federal law. So I'm going to move my image here. I'm going to see if I can get this out of the way, and we'll go get this out, and we'll go this route. Nope, that's not the one I wanted. I want that one. Okay, so I think we've got both sides. The interesting thing is, and I like this was pointed out here, the defense is the side that represents the accused in both criminal and civil. So if I am accused and I'm being sued by someone, I would also be considered the defense. So whether it's criminal or civil, the defense is going to be found in both situations. Prosecution has the responsibility of proving beyond a reasonable doubt, and the defense's job in any trial is to raise the doubt. And in a criminal trial, all they have to do is make sure that it's not beyond a reasonable doubt, and they could be found not guilty. All right, moving on, and maybe not moving on. Okay, we went the wrong direction, and now this is not working with me. All right. Let me It's interesting that nobody took either one of these, so let's make sure we understand the jury process. And I thought we had voir dire. I thought voir dire was in here. Let's make sure we add voir dire. Voir dire is the process of selecting the jury. Now, remember, we had done a video with how jurors are selected, and um, the the very quick video talks about how there's a big jury pool, and the jury pool is first goes through a major questionnaire, and then the attorneys, both the defense and the prosecution, can interview the jurors that are left in the pool, and then they have the ability to strike jurors. There are what we call striking jurors for cause, which means the prosecution or the defense has to give reason why they are striking this person. So I striking this person because they have small children. In this case, is a child abduction case. So they would specifically identify what it is they are asking, so that juror does not sit on the jury. Um, we're striking this juror because her spouse is a police officer, and this is a case involving a police officer. We don't want to have jurors there that might have issues where they're conflicted in a case. So cause is for reason. Then there are the peremptory strikes, which means each juror, and this is decided case by case, the judge will say each side gets 3 strikes. And those are ones where the defense and the prosecution can just say, juror number 3, I don't want that person on the jury, and they don't have to give reasons for this one. We've talked about this time and time again. When they're striking jurors, the one factor that they cannot use to strike jurors, either for cause or in a peremptory strike where they don't have to give reason, is race. So they have to be able to, if there's a pattern of striking jurors and the other attorney starts questioning it, a judge can go back and look to see if there's a pattern and start questioning why those jurors were stricken. So make sure we're understanding one is with reason, one is without telling the judge why, or the other side why they're being stricken. And again, voir dire, I thought I had that slide in here, but apparently, oh, maybe it's in a different spot. We'll check. Once we've gotten the evidence, we've gotten the accused, we've been through trial, then we end up going to the punishment phase, and that's the Eighth Amendment. Very short, very to the point. There will be no excessive fines and bails, and no cruel and unusual punishment. Using it as a sentence, for a parking violation, you will serve 5 years in prison. That's absurd. It's a violation of the Eighth Amendment. That would be crazy. If that were the case, nobody would drive if we ended up in prison for every traffic violation. So again, Eighth Amendment is the punishment phase of the criminal trial process. All right. Capital punishment is a crime that carries with it a possible death sentence. And so a couple examples here. I'm not sure why he put the word John, but Ryan will figure out how that word got put in there. And so Minnesota doesn't have that. We haven't had capital punishment or capital crimes in this state since the early 1900s. 1911 is when they finally got rid of the death penalty here. Many states, there's still 30 plus states that have capital crimes, including the federal government. Our federal government actually still does carry situations of capital crime, and these are big ones. Murder is not necessarily a capital crime in all states. Espionage, treason, yeah. We'll get, I think there's another one up here that's going to get more into detail on that as well. All right, so burden of proof triangle. Let's go through this a little bit. We talked about this, actually the one we talked about was flipped. And we talked about this burden of proof triangle in terms of who has responsibility to prove something. And when we did it, we actually had the triangle the other way, and we had a hunch on the top because that is the one with the least amount of um, information. I mean, a hunch is just, I think I got a gut feeling, whereas the base of it was beyond a reasonable doubt. That beyond a reasonable doubt is that 100%. And I have no problem with this triangle either, because when we're looking here, this peak of the triangle actually represents how much doubt is there. Um, and in beyond a reasonable doubt, there is none. To prove somebody guilty of a crime, it has to be at 100%. Then we ended up with the preponderance of evidence. That's the one where you're in a civil trial. Um, and oops, beep, beep, went backwards. In a civil trial, and it's like that 50% who it's more likely than not that the person's actions led to my injury. That is preponderance of evidence. Probable cause comes next. That is probably around, well, it's under 50%, but that's what's needed for a warrant, police officers, and that reasonable suspicion is what schools need in order to search. We don't need to actually believe a crime has taken place. It has, is, or will take place. We're not at that level in schools. We're at the level of a suspicion, which is below that of probable cause. So we looked at the triangle the other direction. These are just the same. The other one that would be missing on the bottom that we covered is the hunch. So, okay, this got really confusing, so I'm going to try and pick up where this left off. Going through and looking at the slides that are coming ahead of us, I think some things got moved around a little bit, but we'll just keep going from there. So we're going to pick up here with the going back through the 14 steps of the criminal procedure. The one that I don't have on here, obviously, is number 1, which is an arrest, and number 2, which is the investigation. Yeah, it got really weird. So I'm just gonna, this might get a little choppy, so we're just gonna go in order that these slides are in now. So if we go back and we look, remember, number 1 is the arrest, and number 2 is the investigation. And we said in class, investigation can be anything from a couple of hours to months to years, depending on what the case is. Step 3 then is the criminal complaint. And we did spend a number of examples. We went through a number of examples in Crim 1 on the criminal complaint. This is the formal filing of a criminal activity by the prosecution. And so the ones we looked at, we would have looked at Derek Chauvin's. Derek Chauvin's was very simple. There wasn't a lot in his. We looked at the criminal complaint of Byron Smith. We looked at John Ledoux, the young man from Waseca, who planned out the event at the high school. And there might have been a couple other ones here or there that were shown in different classes. But the basic point is they're all the same in Minnesota. They all start with the state of Minnesota versus whoever the defendant is. And then it will go into what the crimes are. And then it will go into the probable cause statement. And so they have that similar format, no matter what we're looking at. And I'm going to switch this around because I think this one got a little out of order. And then, oh, I did that wrong. My apologies. It's not the arrest. Some of you might have caught that. It's the crime, the investigation, then it's the complaint, and then it's the arrest. So I got the first 4 steps. I probably should be teaching this. All right, the next step is the arraignment. The arraignment is often known as the first appearance. It is the first time that the accused is going to stand before a judge. And we went over these, so I'm glad that these are listed in this order. The first thing the judge is going to ask is, do you have legal representation? And I'm going to flip to this one because this is where it comes from, in all honesty. We already gave Connor a hard time about writing this in such detail, but I think he hit every point. The idea that we have the right to have legal representation comes from this one man right here. His case and is the one that said we have the right to have representation with us at any stage of the criminal prosecution that involves the possibility of jail time. And his case is the reason we have public defenders that are there to assist us if we can't afford an attorney. So Clarence Earl Gideon, this little drifter who, was accused of breaking into a pool hall, actually gets a unanimous decision from the Supreme Court to say that he has the right to an attorney and should have had the right to an attorney. Again, his case was retried. He was found not guilty, and the rest is history. In all honesty, that because of him, we have the right to have legal representation. Prior to him, if you remember, it was based on if it was a capital crime or not. So it was a big step from that point on to where we are today. So the second thing that happens in an arraignment is the judge will formally read the charges against the person. Generally, those charges are read from the criminal complaint. They're very formal. It is very pointed that you have violated this statute at this approximate date and time. And, we've seen criminal complaints where there's one or two, to the point where we saw the John Ledoux from Waseca where there were 12, I think, charges read against him. After that, the judge will ask for an initial plea. Do you plead guilty or not? And we've already talked about that most people will identify as not guilty because they don't have to. We're innocent until the prosecution has proven us guilty. And then the judge will go ahead and set bail. And so that's a really important step in the criminal proceeding, is this first appearance. Couple more clarifications. We've talked about this. I made this a specific slide, the indictment. The indictment is the charge. It is the formal notice. It is the charge of whatever statute was violated. And that is the indictment. To indict someone is to formally charge them. So by this point, this term should be drilled into you, and we should, I would hope that anytime I say indict, you are able to quickly identify that as a charge. Another term we went over was, why do most people plead not guilty? Because they can. We are innocent until proven guilty, and I like the fact that in our system, it's not the other way around. I cannot imagine living in a society where you are guilty and you have to prove that you are innocent. There's no way someone can exist in a system like that. I think we have a video here. And so it's as easy as that. I mean, I'm not guilty. I mean, we have cases where we've seen the person commit the crime, and the system is set up so that they have the ability to say, I didn't. You have to prove that I did. And it falls on the prosecution. Setting bail, the difference between bail and parole. Bail is what we've talked about so often, is the money. It's you want to be free, so you give me something of value so that I can
Miss
guarantee
Duncan,
you will
you've been
appear back in
charged with
court.
using a mobile phone while
Parole
driving a motor
is
vehicle.
already
How do you
somebody
intend
has
to
been
plead to this
accused
charge?
and
Not
convicted.
guilty,
They are
Your Honour.
serving
Okay
time,
then, Miss Duncan, I will set
and
this matter down for a
parole
hearing at a
is
later
they are
date.
being given
Now,
a chance to complete a remainder of their sentence, not in custody, but back out in society. So comparing these two will get mixed up, where people will call parole bail and vice versa, but they are very different procedures. One, the parole, again, it is a prisoner. It is somebody being released on good behavior from their sentence, whereas bail is a judge determining, should we release you until your next court appearance, or do you need to put up collateral for that? Following on that one, we've talked about these. What are the conditions for bail? If somebody is going to get bail, um, judge is going to consider a number of factors. They're going to consider, is this person a flight risk? Is this person a danger to themselves or others? And what is the case itself? If this is a major case, as we saw with the indictment of the former president, they didn't even set bail. They literally just allowed him to be. They didn't see him as a flight risk. They didn't see him as a danger to himself or others. And the case wasn't a violent case. I would have been crazy surprised if they would have even considered setting bail for him um, in a situation like that. He has no background. Um, and so when we look at bail, there are the two extremes. The two extremes are the ROR and the remand. The remand is the prosecution saying this person is a danger and this person isn't going to come back on the next court date. This person's going to flee. This person has the means to take off. And so prosecution will ask for remand, and that simply means we keep them in custody until their next court date. When we look at ROR, it stands for release on own recognizance, and that's saying we trust you. We don't need you to give us collateral in exchange for your freedom. We actually trust you on your word that you will return for your next court date. And so, again, ROR is going to be a request from the defense, where remand is going to be a request from the prosecution. And oftentimes a judge will go somewhere in the middle. Many times a judge will go on first-time offenders or nonviolent offenders that they are able to leave without having to post any collateral. However, if they do not return, as we've talked about, there is a warrant for their arrest because it is an obstruction of justice. All right, so the next hearing then is the probable cause hearing. So we've gone from crime, investigation, criminal complaint, and arrest, first appearance. Then there's these two other appearances or hearings that are really crucial to someone who's been accused of a crime. And so the probable cause hearing is where the judge will determine, is there any violation that took place on the side of the police? Was there an arrest warrant, or was there a proper warrant? Was it used? Was it violated? Did the police have reason to take the person into custody? Did the police even have reason to, for instance, conduct a traffic stop? So this is the part of the case where the judge is going to say, I don't want any surprises. I want to know if there are any possible violations out there of the person's rights, because if there are, there's evidence that could potentially be thrown out of the case. And so they go through these hearings with the hope that they can eliminate any possible surprises down the road, where they've already got a jury, they've already got everything set, and then something comes out that says, well, the police may have violated the person's Fourth Amendment in this area. The other hearing then is the omnibus hearing. And that is one where, um, this is checking on, and I got to move this down. This is checking on were there any other violations? Um, the person's other violation to their rights. So this one's looking at any Fifth Amendment, oops, wrong one, any Fifth Amendment violations. So was this person taken into custody and forced to give information? Was this person mistreated while they were being interrogated? They're going to look to see were there any Sixth Amendment violations? Did this person ask for an attorney and they weren't allowed to have an attorney present during parts of the investigation or when the police were questioning? So again, it's very similar to that of the probable cause. The police doesn't want to have a surprise. They don't want there to all of a sudden be something come up during the trial where all of a sudden information gets thrown out because there was a violation of the person's rights, which means the whole case is in jeopardy. So, looking ahead, I think this is probably a fair place to stop, so that we can finish this up on Tuesday, and then we will still plan to test on Wednesday. So if there's anything that you want me to go through that I may have gone through really quick today, I want you to write it down so that tomorrow I will be able to pick that up and move forward from there. So we will talk tomorrow.